Welcome to Middle Class Matters. Today, 13th June 2023, Business News in English from Dr. CMA MA Allegation. Report of the Expert Committee constituted by the Honorable Supreme Court of India on Adani Matters. Chapter number 4. Alleged Contraventions and Regulatory Failure. Introduction and Context. 1. In examining the remit of the committee under paragraph 15C of the Honorable Supreme Court's order dated March 2, 2023, the committee kept sharp focus on the contents of para 10, which spelled out the specific areas on which SEBI's probe must focus and on which SEBI must apprise the committee. Point number 2. The three areas of investigation spelled out are: A. Whether there has been a violation of Rule 19A of Securities Contracts Regulations Rules 1957. B. Whether there has been a failure to disclose transactions with related parties and other relevant information which concerns related parties to SEBI in accordance with law, and C. Whether there was any manipulation of stock prices in contravention of existing laws. Point number 3. These are taken up in sequence as sub-chapters in this chapter. Minimum Public Shareholding Regulatory Framework. Point number 4. The first aspect directed for investigation by the Honorable Supreme Court in its order dated March 2, 2023 is whether there has been a violation of Rule 19A of the Securities Contracts Regulations Rules 1957. This is the provision dealing with the minimum public shareholding stipulation for listed companies to adhere to. Point number 5. Public shareholding is essentially shareholding in the hands of all shareholders other than the promoters and the promoter group. The need for regulations to stipulate a minimum level of public shareholding has multiple objectives. A good float of shares that are not locked up from trading would lead to a good prospect of price discovery. Greater the frequency of trading in shares of a company, greater the depth of quality of the price discovery in the shares, and lesser the chance of the price being volatile, since higher the volatility, greater the ability to absorb spurt in demand or supply. 6. Point number 6. Rule 19A of the SCRR as it now stands is extracted with all the footnotes that show the legislative history since its introduction in June 2010 in Annexure A to this report. Point number 7. Even a plain reading would show that Rule 19A was introduced in June 2010 and has all along been subject of frequent and repeated amendments. The complexity of public sector undertakings and the temptation to treat them differently has also left its imprint on the provision. Point number 8. From a region of having to maintain a very high mandatory public shareholding to a regime where different companies have different standards to meet to remain compliant, to a regime where all companies by and large comply with a common standard, the law governing minimum public shareholding has truly had a checkered history. It would be useful to examine this history in brief. Point number 9. When India introduced exchange controls and forced multinationals to list their subsidiaries in India in the 1970s, promoter stake was to be kept at 40%, with minimum public offers of 60% being mandated by law. This changed when India opened up in 1990s. Point number 10. Suffices it to say that the first serious reform towards the current regime took place in August 2005. SEBI introduced a policy change which was well intended, but created multiple classes of companies with various public shareholdings. In a nutshell, the change introduced could be summarized thus. A. As a general rule, every listed company was to ordinarily maintain a public shareholding of at least 25%. B. However, since Rule 19(2)(b) permitted making a public offer with just 10% of the offer to the public, Such companies would be compliant if they maintained a minimum public shareholding of 10%. C. Government companies, infrastructure companies, and industrial companies were exempt from minimum public shareholding requirements. D. Listed companies that were not compliant in 2005 were given 2 years to become compliant. E. Listed companies that may become non-compliant due to issuance of shares that led to a breach of the minimum public shareholding for reasons such as corporate debt restructuring packages would get 1 year to become compliant. F. SEBI indicated that the ultimate objective is to reach a single level of minimum public shareholding for all, but did not stipulate an eventual time frame for reaching this objective. Point number 11. It was on June 4, 2010 that Rule 19A was introduced into the SCRR. From this stage, two instruments of law dealt with minimum public shareholding: the listing agreement to be executed with stock exchanges and the SCRR. Point number 12. Originally, different companies had different standards to comply with, and that was eventually streamlined to every listed company having to comply with a 25% minimum public shareholding. Time was given to companies to adhere to the new standard, and there has been suspicion that many promoters of corporates would be prompt to strike deals with friends and families to hold shares on their behalf and take on the role of public shareholders, but given the influence or control over them, such holdings was suspected as not being truly public shareholding. Point number 13. The entire point of a minimum public shareholding norm was that there should be a free float available for price discovery. Shares held in the hands of public shareholders would not have any strings attached to the promoters, and they would be free to trade in them without having to take consent of any promoter and without being subject to any preemptive right, such as right of first refusal or right of last refusal. Point number 14. Therefore, SEBI began regulating the manner in which compliance with minimum public shareholding may be achieved. SEBI got prescriptive in this regard and spelled out the specific types of transactions by which a listed company could become compliant with minimum public shareholding. A concept of an offer for sale in the secondary market without having to write a prospectus was introduced, with micro-regulation requiring offers to institutional investors with attendant norms. In the interest of brevity, the acute detail of such requirements is not being spelled out here. Point number 15. The direct benefit of public shareholding having depth is that trading in the market would then have depth, and therefore frequency of trading would be higher, leading to better price discovery for the listed securities. It is in this context that the allegations about the listed Adani companies in connection with minimum public shareholdings must be considered, and for the committee to examine if there is a regulatory failure or shortcoming in meeting the objectives for which the regulations have been made. Point number 16. Therefore, since public shareholding is about the ability of a shareholder to decide for himself to trade in the shares without reference to the promoter and without strings attached to the promoters, the vexed question is to see who can actually take decisions on what to do with these shares. FBI regulatory framework. Point number 17. This is where the regulatory framework governing foreign portfolio investors come in. A quick word on the march of this law would be useful before going into the factual matrix involving listed Adani companies. Point number 18. Initially, when India opened up its market in 1991 for cross-border investment in the stock market, a category of investors were created with freedom to make portfolio investments in Indian companies. Any investment of not more than 10% were considered portfolio investment, and institutional investors who registered themselves with SEBI were permitted to trade freely on the Indian stock market. Point number 19. The Indian rupee was then not and still is not fully and freely convertible on the capital account. Foreign institutional investors FIIs registered with SEBI could freely buy and sell shares on Indian stock exchanges, and they could remit money inwards and outwards subject to their investments being compliant with what was specifically allowed. For instance, no FII could hold more than 10% in a listed company. It is another matter that different FIIs could collectively hold more in a listed company. Other obligations were imposed, such as ensuring that assets in India are held only through a custodian, another form of registered market intermediary, ensuring that funds flowed into and out of India only through a pre-identified designated bank account, and so on. Point number 20. Over time, the requirement to register as an FII and comply with various regulatory requirements was considered by the market to be burdensome, and a product termed the overseas derivative instrument, colloquially and popularly called participatory notes, emerged. ODIs were nothing but bilateral contracts between an investor and an FII, whereby the FII would make an investment using its registration but pass on the risk and reward of the investment to a third party who would provide funds to the FII. The ODI market represented a significant component of secondary market trading at one time, and policymakers felt the burden of compliance in accessing the Indian market was leading to inefficiencies and opaque sources of investments into India. Point number 21. Based on the recommendations of the working group on capital inflows, where one of us was a member, a concept of a foreign portfolio investor (FPI) was introduced. The idea was to make registering to invest in the Indian stock market easier, so that more investors from abroad would have access to the Indian markets and would not have to be captive to the rent sought by FIIs, who alone enjoyed the privilege of investing in India. All existing FIIs were migrated to an FPI status. Since a foreign investor who would have to otherwise find an FII to contract an ODI could directly come into India as an FPI, the economic rationale for a booming ODI market was also undermined, removing the inefficiency in market access for foreign investors. Point number 22. The process of registering too was simplified. Rather than having to interact with the SEBI to register, an FPI could designate and register with any depository participant (DP), who would in turn provide access to the Indian market instead of an FII. The designated depository participant would be the one who would open a demat account for the FPI and monitor the trades from the perspective of regulatory compliance. Point number 23. It is in this light that the SEBI Foreign Portfolio Investors Regulations 2014, that is FPI Regulations 2014, were conceived. Point number 24. It is noteworthy that the FPI Regulations 2014 in fact had stipulated a requirement that FPIs must not have an opaque structure. Regulation 32(1)(f) of the FPI Regulations 2014 originally provided as follows. F. Ensure that foreign portfolio investor does not have opaque structure or structures. Explanation 1. For the purpose of this class, opaque structure shall mean any structure such as protected shell company, segregated shell company or equivalent, where the details of ultimate beneficial owners were not accessible, or where the beneficial owners were ring-fenced from each other, or where the beneficial owners are ring-fenced with regard to enforcement, provided that the foreign portfolio investor satisfying the following criteria shall not be treated as having opaque structure. 1. The applicant is regulated in its home jurisdiction. 2. Each fund or sub-fund in the applicant satisfies broad-based criteria. And 3. The applicant gives an undertaking to provide information regarding its beneficial owners as and when board seeks this information. Explanation 2. For the purposes of explanation 1, the definition of benefit of ultimate beneficial owner shall be as provided under the Master Circular on Anti-Money Laundering Standards or Compacting the Financing of Terrorism issued by the board from time to time. Like the video, please subscribe to the channel, give your comments. Thanks for watching.